Hello, good evening. This will be our first lesson for this semester. Our semester is divided into 9 weeks, and this is actually this is our third week. But what we did last week is just a simulation of what we will be doing for the entire semester. Okay, so let us proceed. Our subject is labor relation and negotiation. At the end of this unit, students are expected to, number one, analyze the necessity and importance of constitutional provision on labor and other legal terms. Economy is an indispensable aspect in the development of a country. Global prepositioning and ranking is based on the financial capability of one, and international trade is founded on how lucrative bargaining relations are made. The increase or decrease of Philippine economy can be gleaned at the micro perspective of the laborer, them being the other half of our economy. Remember, our economy is divided into two. Number one, with regard to the employer, and number two, the laborer. Although we have other stakeholders such as government, competitor, and the environment. It is in this juncture that pertinent discussions on the constitutional framework of labor should be done for readers to realize their necessity and why regulations are expected to be made. This chapter provides an overview of the origin of labor laws and its relation to labor legislation. To fully realize the purpose of this chapter, a question is posed for clarity, which is, how does the present Constitution interplay with certain labor provision? For our first work, a formative work, in one word, describe the Philippine worker. So I would be expecting all of you to have your own notebook. Our quizzes as well as our question guides, work assessment should be placed in your notebook other than our canvas. So bukod doon sa canvas na may mga katanungan doon, I expect students to write down their formative quizzes doon sa kanilang notebook. So again, for our first assessment, in one word, describe the Philippine worker. It is but appropriate that every theme or topic be studied in its origin in order that enthusiasts, readers, or professionals are given proper information for them to understand the whys and the hows. A prelude on the study of labor relation and negotiation should be traced from its source, which is the Constitution. The Constitution is the supreme law of the land, Chef Jacques 2011. It is the fundamental law of the land, De Leon 2005. These definitions would mean that as the supreme and fundamental law, it lays down basic principles and guidelines that regulate relationship between the sovereign, which is the state, and its subject, the people. The provision of the Philippine Constitution is very clear in stating their view on the necessity of labor vis-a-vis the economic sector. It states that labor affirms as a primary social economic force the laborer, and thus it shall protect the rights of workers and promote their welfare. These statements can be seen in Article 2, Section 18 of the 1987 Philippine Constitution. The constitutional connection between the state and laborer who suggests an amorous relationship and creates an impression with a favorable impact. The constitutional preference of labor over employer is not injustice or unfair treatment against the latter. It is just a show of empathy on its part, since the laborer had less than what the employers have. Borrowing the words of President Ramon Magsaysay, He who has less in life should have more in law. This favorable leeway, though, should not be a ground that employees are given the right to commit abusive behavior on their employers. People should at least give what is due and not should take everything for themselves. This inclination of the courts in upholding the employee's rights should not be blind. The Supreme Court had ruled that justice is for the deserving.
Our meeting last semester, we our meeting last semester.
Article 13, Section 3 of the 1987 Philippine Constitution, Paragraph 1 states that the state shall afford full protection to labor, local and overseas, organized and unorganized, and promote full employment and equality of employment opportunity for all. This provision, class, encompasses everything in labor. So ano ba yung ibig sabihin nito? Ibig sabihin na the state, through our government, should give protection. Kailangan protektahan ng gobyerno natin ang mga manggagawa, regardless of their domain, regardless kung nasaan sila. Nasa abroad man sila o dito sa Pilipinas nagtatrabaho. Regardless kung sila ay organized or kung sila ay hindi organized. And also, it is expected from the state to promote full employment and equality of employment opportunity for all. Katulad ng binanggit ko noong nakaraang semester, what is needed here is an opportunity. The opportunity that everybody will be given, kung kaya naman niya, kung meron naman siyang qualification, should be given work, trabaho. At hindi lang ibinibigay sa limited few. Hindi lang ibinibigay sa mga matataas ang patungkulan o matataas ang natapos. Another provision, Article 13, Section 3, 1997 Philippine Constitution, Paragraph 2, it shall guarantee the rights of all workers to self-organization, collective bargaining and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, humane conditions of work, and a living wage. They shall also participate in policy and decision-making process, affecting their rights and benefits as may be provided by law. Isa-isahin natin yung mga importanteng provision ng paragraph 2 na ito. So number 1, ano ba yung mga guarantees na ibibigay ng gobyerno sa mga manggagawa? Number 1, the right of all workers to self-organization. Karapatan ng mga manggagawa na sumama, makilahok, bumuo ng isang labor organization. As long as this labor organization does not perform any illicit or illegal activities as decided by certain laws. Collective bargaining and negotiation. In some future discussion, we will be discussing what collective bargaining is, as well as negotiation. Pero for purposes of easy reference for this meeting, kapag sinabi natin collective bargaining, ito po yung panahon kung kailan dapat mag-usap si employer at si employee. Okay? This guarantee is left to both of them. Hindi po pwede na si employer lang ang gusto makipag-usap and vice versa. Hindi rin po pwede na si employee lang ang gusto makipag-usap kay employer. Ano ba yung terms and conditions ng collective bargaining? Well, it depends. No? Dependent siya kung ano ba yung pinag-usapan nilang dalawa. With regard to security of tenure, with regard to wages, with regard to the environment. So, pumapasok na doon sa collective bargaining kung ano ba yung agreement nila with regard to how they should work. And also negotiation. Negotiation is also a process of collective bargaining. Another guarantee is that employees are allowed to perform peaceful concerted activities. An example of this is the right to strike in accordance with law. Very basic yung word na peaceful. Doon sa mga concerted activities, mass action, for example, all of these should be peaceful. Kailangan walang gulo, kailangan walang violence. Kasi we all know for a fact that if violence would occur, for sure may mga heated arguments dyan, may mag-aaway. So instead na magka-come up sila sa isang amicable settlement, mas lalong magkakagulo pa yung kanilang pag-uusap. They shall be entitled to security of tenure. Kapag sinabi natin security of tenure, this is the period in time wherein a worker could not be dispensed or terminated easily. A process should be done. Also, another entitlement is for employees to be under humane conditions of work. Ito dapat yung environment nila. They should perform their work as much as possible conveniently. Human nature kasi natin na if we are suffering or if we encounter certain problems in the way we work, in our surroundings, tendency niyan, our emotions would go out, maraming po pwede mangyari, magiging less productive tayo, yung efficiency natin, effectiveness, mawawala sa trabaho natin. And also a living wage, yung sweldo na tama, karapat-dapat sa isang empleyado, yung isang sweldo na makakabuhay ng pamilya. The last sentence of paragraph 2 speaks of another guarantee, that laborers are now allowed under the present constitution to participate in policy and decision-making processes. Pinapayagan na sila ngayon na makilahok sa mga pag-uusap na patungkol sa kanilang karapatan, patungkol sa mga benepisyo na dapat ibigay sa kanila. Paragraph 3 provides that the state shall promote the principle of shared responsibility between workers and employers. Shared responsibility. If a company, katulad ng binanggit ko last time sa inyo, if a company would have increased sales, hindi lang po pwedeng sabihin na dahil magaling sa employer. Vice versa, ganun din. Hindi po pwedeng sabihin na kaya mataas ang sales natin dahil yung mga empleyado nagpo-produce sila. Madami silang ginagawa. They are efficient, they are effective. Hindi po. Okay. Mutual po ito para mas gumanda yung relasyon sa isang trabaho, kailangan pareho sila nagpa-participate. Pareho silang gumagawa at ginagawa yung trabaho nila. They shall preferentially use voluntary modes in settling dispute. Kung meron silang hindi pagkakaunawaan, the first thing that they should do, voluntarily dapat, ay dalhin yung kanilang grievances sa proper forum at dapat nilang pag-usapan. Hindi yung bigla na lang silang lalabas, mag-i-strike, hindi yung bigla na lang sila mag-file ng kaso, hindi yung bigla na lang sa social media. Yun po yung madalas na nangyayari ngayon every grievances, no matter how light po, automatic dinadala sa social media. This is a no-no po. Kailangan mo nilang pag-usapan. At kung hindi nakuha sa tamang pag-usapan, i-elevate sa proper forum. They shall also enforce mutual compliance and foster industrial peace. So kailangan po nila sundin yung mga alituntunin para magkaroon ng isang harmonious relationship. Paragraph 4. The state shall regulate the relations between workers and employers. So, since the state now is given the right to control, to regulate the relationship between workers and employers, all that is needed to be done is for the laborers and for the employers to follow the provision of the law. The state also recognize the right of labor to its just share in the fruits of production. So what does this mean? Ano ba yung share doon sa fruits of production? We could sum up this doon sa sweldo ng mga employees, doon sa mga benefits na dapat naman ibigay sa mga employees. Sa kabilang banda, sa part naman ni employer, the right of enterprise to reasonable return of investment, which is ROI, and expansion and growth. So employers now can have their ROIs, and also they can expand. They can look for other branches. Article 2, Section 18 of the 1987 Constitution also provides that the state affirms labor as a primary social economic force. It shall protect the rights of workers and promote their welfare. So I mentioned this a while ago. Ito yung pinanggagalingan, pinaghuhugutan. Na ang gobyerno, ang Estado through the government should protect these laborers. The employers can protect themselves. Although there are certain provisions that the law would also provide them certain benefits, katulad nga ng expansion and growth, ROIs, and the rest. The state should also protect the rights of workers and promote their welfare through enactment of laws. What are the other guarantees provided for by the Labor Code? Kanina, nabanggit ko yung mga guarantees na binibigay ng Constitution. So, itong part na ito naman yung mga guarantees na binibigay ng Labor Code mismo. So, si Labor Code, PD 442, siya po yung nag-encompass. Siya po yung nag-provide verbatimly kung ano ba yung comprehensive na binibigay ng Constitution. So, let us have them one by one. So, number 1, to afford protection to labor. Number 2, promote full employment. Number 3, to ensure equal work opportunities regardless of sex, age, or creed. Kaya nga, we have this new law which forbids discrimination with regard to gender, with regard to age. As long as the applicant is qualified, as long as the applicant can perform his work, as long as he passes all the test requirements given by the employer, then he should be allowed to work. Number 4, regulate relations between workers and employers. And also, assure the rights of workers to a just and humane conditions of work, self-organization, security of tenure, and collective bargaining. So kung papansinin ninyo, nakasaad na ito sa Constitution, yet the Labor Code provided for them verbatimly. Mas lalo niyang in detail sinabi kung ano ba yung mga ibig sabihin nito. One question, what does security of tenure mean? Ano ba yung security of tenure? Nabanggit yun na kanina, but let us have a little discussion on this. It is a constitutional or legal guarantee that an employee cannot be removed from work apart from exceptional and specified circumstances. So, itong sinasabi exceptional and specified circumstances, ito yung mga bagay na kapag ginawa ni employee, no matter na meron na siyang security of tenure, still he may be removed from office. Still he may be dismissed. However, his dismissal or removal should be just, should go within the due process. Kailangan pa rin sumunod sa due process. Meron pa rin protocol, may procedure pa rin na dapat sundin bago siya totally ma-terminate or bago siya totally ma-dismiss. In the absence of a security of tenure, the ability to carry out powers, functions, and duties by the employee might be restricted by the fear that whoever disapproves any of his decision may be able to simply remove him from office or vengeance. Ito yung purpose kung bakit kailangan natin ng security of tenure. Okay? Minsan kasi kung hindi tayo maglalagay ng security of tenure, the employees may have certain fear sa kanya na I should follow the instruction of my employer, of my supervisor, no matter how illegal that instruction is. Dahil baka pwede ako matanggal. Kaya sabi ng batas natin, no. Meron kang security of tenure. If you have the security of tenure, and if the instructions is illicit or illegal, then pwede mong tanggihan yung pagsunod doon sa instruction na binigay sa'yo. Halimbawa, sabihin natin, binigyan ng instruction si employee, binigyan ng instruction ni employer sa employee na nakawan mo nga ako, o kaya patayin mo nga yung co-employee mo dahil galit ako sa kanya. Ayaw ko sa pagmumukha niya na nasasora ako kapag nakikita ko siya. At ikaw naman, dahil alam mo na kapag hindi mo sinunod yung instruction na yun, baka pwede ako matanggal. Baka pwede ako ma-terminate dito. And because of that fear, gagawin mo na lang yun. Okay? So, if you know that the instruction, again, is illicit or illegal, then, pwede mong tanggihan. Otherwise, sa'yo, babalik yung consequence ng paggawa mo ng illicit or illegal activity na yun. What is collective bargaining? It is a procedural requirement between employees and employers to amicably arrive at a settled working agreement. This sacred compact would form as a basis of contractual stipulation, and any contravention of either party may be a ground for any peaceful concerted activity. So kapag sinabing collective bargaining, isa itong legal requirement na kung meron dapat pag-usapan si employer and employee for them to have a dialogue at pag-usapan yung terms and condition ng collective bargaining. So, yung output ng collective bargaining ay collective bargaining agreement. Collective bargaining is a process, and collective bargaining agreement is the output of the process. Okay, the last portion mentioned that this is a sacred compact. Kailangan sumunod the employer at the employee kung ano man yung terms and condition ng collective bargaining agreement. And kung merong hindi sumunod doon sa term, any stipulation, any condition, then this may be a ground for lockout sa part ng employer or strike or any peaceful concerted activity sa part naman ni employee. What is self-organization? An organization is any association, union, the purpose of which is to solidify employees for the protection of any labor claim arising from violation of collective bargaining. Ang parati ko po dinidiin sa mga estudyante ko with regard sa necessity ng pag-self-organize. Ang tinig ng isang manggagawa ay mahina kumpara sa tinig ng mas nakakadaming manggagawa. Mas may puwersa po ito. Forceful. Kaya pong enganyuhin si employer na sumunod doon sa kanilang mga demands. As long as the demands ay licit, legal, and within the bounds of law, as well as within the bounds of their collective bargaining agreement. What is just and humane working conditions? It is a principle wherein laborers should not be placed in an environment evidently harmful to their health or which may cause impending injury. Isa po itong environment, yung lugar kung saan tayo nagtrabaho, which should be acceptable sa nature ng tao, na hindi naman siya masyadong ma-stress out, hindi naman siya uncomfortable, inconvenient sa pagtrabaho niya, and also it should be safe sa kanya. We will be having a separate chapter for this. One important thing to note is what happened with Kentex. Okay, siguro medyo fresh pa sa atin si Kentex. Kung sana sumunod sa regulation yung employer ni Kentex, kung sana sumunod sa probisyon ng batas, then wala sana namatay, wala sana nagkaroon ng injury. And Kentex is just one of the several irregularities na ginagawa. Madami pa dyan. We have PPEs. Ngayon, we are facing this pandemic, and it is expected that frontliners, practitioners, doctors, nurses, for example, they should be afforded with PPEs. Kailangan silang personal protective equipment or gear. Remind you, personal, hindi hiraman. Kasi kung naghihiraman sila ng kanilang PPE, then baliwala yung PPE na ito. And it should protect them from a possible injury, from death, from contamination, from disease. Hindi yung PPE na isang pitik mo lang, magkakaroon na kaagad ng gasgas, masisira na kaagad. So useless din to. There are times kasi, if you would look at the mindset of the employer, for them, to some, hindi ko naman nilalahad, to some, they see PPEs as another cost. Dagdag sa budget nila. Dagdag expenses. Pero, ano ba dapat ang mas binibigyan nila ng priority? Yung expenses ba? O yung health ng mga manggagawa nila? So, ito yung dapat yung titignan nila. What is social justice? Very legal yung term ng social justice. And our Supreme Court, through Justice Laurel, defined what social justice is. Under the case of Kalalang versus Williams, it is neither communism, nor despotism, nor atomism, nor anarchy, but the humanization of laws and equalization of social and economic forces by the state, so that justice in its rational and objectively secular conception may at least be approximated. Social justice means the promotion of the welfare of all people, the adoption of government to measures calculated to ensure economic stability. Okay. To at least define in layman's term what social justice is. Kapag sinabi natin social justice, it is a harmonious relationship between all stakeholders. The government, the laborers, employers, everybody. Okay? That everybody should be treated equally, pantay-pantay. No favoritism. That the employer should provide for the welfare of the people. The government should provide for the well-being of its employees. Kapakanan ng kanyang manggagawa. Kasi if the employer would give all the benefits as provided by law, provide for the rights of employees, isa lang naman yung output niyan. Yung magiging grateful yung employee sa mga employer, and they would work hard. They would be productive. They would treat their work as their own. Social justice policy mandates a compassionate attitude towards the working class in its relation with management, who should look at them with sympathy, remembering that they are equal partners. The employer should not treat employees as mga trabahador lang kayo. Without them, kung wala sila sa picture, walang mangyayari sa business, walang mangyayari sa negosyo. Sir, age na po ng computer, age na po ng technology. Remember fire, the fourth industrial revolution. So we do not need people as a factor para tumaas ang sales natin. That's wrong. That is wrong. Still, somebody should press the button. Computer would not move without a person na pipindot ng button niya. There should be somebody behind the wheels. There should be somebody na nag-ooperate itong mga makinang ito. So people is indispensable. In our module, in our syllabus, I provided for several jurisprudence. Kapag sinabing jurisprudence, these are Supreme Court decision. So itong Supreme Court decisions nito, this would also form as a guide sa court whenever they would provide for decision in any problem filed sa kanila. So in one case, the case of Magsaysay Maritime versus NLRC, it held that the constitutional policy to provide full protection to labor is not meant to be a sword to oppress the employer. The commitment of the court from sustaining the employer when it is on the right justice is in every case for the deserving. This is another definition of social justice. Hindi ibig sabihin na yung mga manggagawa, pwede nilang ipwersa lahat ng gusto nila. If the court would find out na oppressing naman, one-sided naman din, kung gusto ng manggagawa din, they would definitely side the employer. For example, with regard to the setting of minimum wage, okay, hindi po pwede na ang i-insist ni employee is more than, masigit pa, dun sa kaya na ibigay na employer. They should meet halfway. They should meet halfway. What does rule of law mean? It embodies the basic principle of equal treatment, all people before the law, fairness and both constitutional and actual guarantees of basic human rights. A predictable legal system with fair, transparent, and effective judicial institution is essential to the protection of citizens against the arbitrary use of state authority and lawless acts of both organization and individuals. SEPSHAC 2011. So, simply, pag sinabing rule of law, everybody should be treated equally. It is equal treatment before the law. This is a guarantee, constitutional guarantee, of basic human rights. The reason why, if you are familiar with Lady Justice, siya yung babae nakaputi, nakagown, may hawak na scale, then may hawak sword sa kabila. The reason why, ang sabi nga, siya ay nakapiring para hindi niya makita kung sino man yung taong lumalapit sa kanya. And the only thing that would say that that person is guilty or not, or the decision should be favorable or not, would be the scale. Titimbangin yung scale na yun, and if it is favorable doon sa the person who complained or the respondent, then para sa kanya. And then the purpose of the sword is to cut down, to trim down, if there are any illegal actions performed. Now, this is just our first module. The important thing is, before we should proceed with the provision of the labor code, we should at least have an idea of constitutional provision. Dahil dito naman nanggaling yung labor provision legislations na ginagawa ng ating mga senador, mga congressmen natin. Okay? Thank you. Good evening. Hoping to see you in some future discussion. Thank you.